Welcome, welcome, welcome. Good morning to those of you on the West Coast, and good afternoon to those of you on the East Coast. Warm hello to everyone in between. My name is Dan Balkaran, and I'll be your employment lawyer for the next half an hour or so. As you can see on the screen, I'm an employment lawyer at Samfiru Tumarkin LLP, practicing out of British Columbia. Samfiru Tumarkin is, of course, Canada's leading employee side employment law firm. Now, if you have any questions, as always, please send them in. If you want to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and of course, 1-855-821-5900. Okay, we got some questions rolling in. Let's get started. Deanna asks, I went on disability leave for 2 months. When I tried to return to my job, my employer said my position was filled and they will keep me posted. What can I do? Okay, so the human rights legislation applicable to you either federally, if you're a federally regulated employee, or provincially, requires your employer to return you to your job or a job substantially similar to the job that you had when you left for your injury. And so if they don't, it's discriminatory. And I think in this case, it's arguably a termination. Like, they're not saying, well, we don't have a position for you that can accommodate your disability. They're saying, we're just not bringing you back. And so I think that you have different avenues of redress. You could bring a human rights complaint to try to get them to put you back in your position. Now, in British Columbia, the Human Rights Tribunal is famously backlogged due to, I guess we'll say it's short-staffed and underfunded, but years and years. So your ability to get some sort of resolution that way is limited. If severance is something that's attractive to you, and it can be. I mean, severance can be as much as 24 months at your wage, depending on what your employment contract says and your age, your length of service, and the position that you held. You may want to go after, treat it as a termination, go after your severance, but you may not. It may be that you like the job, you've only have a small amount of severance coming to you. The job is the thing, and it may be that another strategy to force your employer to return you to your job is what you need to do. In that case, I'm never a big fan of, if you want to maintain the marriage with the job, you don't have a lawyer send a letter, because usually that ultimately will cause a divorce, we'll say. But that is a potential option. You hire a lawyer to write a letter to say, listen, you were in violation squarely of whatever applicable human rights act that is enforceable or that is applicable in your jurisdiction. You're squarely in violation of it. You need to return her to a position now, or else, or face whatever it is, the remedies that you'd be threatening. So you could do that. I'm not a big fan of that, but in all cases, Deanna, I don't have enough information. You need to talk to an employment lawyer, and you need to do so. I would say right away, because I don't know the nature of your injuries. I don't know what grounds your employer is stating for not returning you to work. I don't know if it can't accommodate you, or if it just straight up says, we filled your position with somebody else. Did they put this in writing? It'd be great if they did. So Deanna, you need to talk to an employment lawyer. If you want to talk to us, you can do so. Employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay. All right. I'm not going to say specifically what this person's handle is, so I'll just go with, I'll call them Allie, because their Allie is in their handle. So a question from Allie. I've been told the company is closing in 12 months' time. Is this considered verbal notice? Am I not owed any severance in this case? Well, that's a great question. All right. So the thing that you're entitled to at law, in the event that your job comes to an end without cause. Without cause simply means that the employer does not have a legally justifiable reason to provide you with zero. Okay, and that would be, a just cause reason would be like you punch your boss in the face, or you come into work high on drugs, or stealing, theft, you commit an indictable offense, that sort of thing. So barring one of those, you're entitled to a heads up of your termination, right? So Ali, the bad news is, we're going to get let go of you in 12 months, or we're letting you go in 12 months. Bad news is 12 months from now, you'll no longer work here. The good news is you're going to continue to draw a paycheck for those 12 months, and we'll give you time off to look for a job, and hopefully you find one so you're not unemployed for very long, if at all. That's called notice, often called working notice. That's all you're entitled to at law. Okay? And the amount of the working notice varies depending upon what your employment contract says, and your age, length of service, and the position you hold. Okay, so it's impossible to give any sort of certainty and specificity about that. However, 95% of the time, this is my sort of estimate, but 95% of the time, employers don't give working notice. They choose to fire somebody today. And if you fire somebody today, you still have that entitlement to working notice. It's just that entitlement, they can't give you the notice. They can't give you your 12 months notice if today was your last day. So that 12 months converts into money. And that money is what we call severance. So severance is just simply the money you would have made had you worked out the working notice period. So as far as the calculation is concerned, severance and working notice are interchangeable, but your legal entitlement only is to the notice, the working notice. Okay, and so if they've told you your last day is going to be on August 1st, 2024, then that is good and valid working notice of your termination. Okay, but the question is, what does your employment contract say? And then what is the mixture of your age, length of service, and position entitle you to? So if you have 24 months coming to you, they've given you 12 months working notice. They're hoping you find a job in the interim so they don't have to pay you on the back end. But you wait for those 12 months to go by. And then the day after your 12 months expires and you're no longer working there, then you say to them, I want the remaining 12 months. And since I'm not working here anymore, I want it in a lump sum. That's usually what you do in that situation. But if you're only owed 9 months, okay, of working notice, of working notice, then they've exceeded that, then you don't have a claim to anything else. Okay. And so, but if the working notice, like your end date is fuzzy, this is the important thing, Ali. If your end date is fuzzy, like you're not clear when it's going to be, you just know that at some point in the future the company is going to close, then it's not clear. Let me rephrase that. Then it could be you don't actually have proper working notice, and you can go after your full severance after your last day, or at least closer to your last day when it becomes certain, right? Because a lot of times that happens. There's lots of law that talks about that, where if the last day keeps moving and you never know when your last day is going to be, you don't actually have working notice. And that matters when you're going after the lump sum money at the end, because any amount of lump sum is reduced to the extent of the working notice. So, Ali, lots of complicated permutations coming off your question. I certainly can't answer them in all anyway, in just sort of based on your one paragraph and the information you provided. So I'm going to sound like a broken record today, but Ali, you need to talk to an employment lawyer. I do it right away. If you want to get a hold of us, contact us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Ali, I'd also just raise one more point. The company's closing. Does it have any money? Will it have any money? Right? I think that's the overriding question here, right? For you, is it going to be able to pay you for all those 12 months? If you have a claim on the back end of that, are you going to be able to get paid, or are you trying to get blood from a stone, or from a stone that is going bankrupt? These are really important questions that you have to ask, because bird in the hand is worth two in the bush, and if you have a great claim to 24 months but you'll never see it, or you can get 12 now in hand, You want the 12. There's 12 months in hand is better than 0 months, at any other time. So talk to an employment lawyer right away to help you with all those questions. Thanks, Ali. Steven asks, my partner needs to go for a major surgery and I need time off to provide care. My employer has said I need to use my vacation time for this. Is that correct? So I actually don't know the answer to this question, unfortunately, and I apologize for that, Stephen. Uh, Various different Employment Standards Act, if you are provincially regulated, provides time off for leave, paid leave, but in situations like this, usually I don't believe there's bereavement leave, but that's not what's happening here. This is sort of quality of life, not quality of life care. It's necessary care for your partner during this period. I don't know how much time we're talking about. Are we talking about 6 months that you're going to be out, or are you talking about a few weeks? So the question is, if you want to get paid, do you have to use your vacation pay? I would think yes, because you're asking to take time off, not for your medical issue, but for somebody else's, and you want to get paid for it. To me, that does sound like you'd have to use your vacation pay for that. Yeah, and you'd continue to get paid. It's just you're using your vacation to look after your partner as opposed to going to California or something. I think that's probably correct, but there might be something in your applicable Employment Standards Act, if you're provincially regulated, that says otherwise. You may wish to speak to an employment lawyer and have them look that up specifically, or maybe that employment lawyer would know off the top of their head. I certainly don't know the answer to that question. I think my gut tells me you probably have to use your vacation pay or take unpaid leave, which of course means you don't get paid, or a mixture of the two. But I think your employer is probably right. I also think, Stephen, the solution here is an amicable one. So, I don't know how long you've been here, but you got like 20 years of skin in the game. You might want to say, like, listen, I've been here 20 years. Can you sort of meet me halfway on this one? Can you, I'm taking 3 weeks off. Can you pay me for a week, and then I'll use vacation for 1 week and I'll take unpaid leave for the other week? Yeah, they might do it, but I don't think you got a hammer here. I think this is all just goodwill. Could be wrong, but those are my thoughts. Wilford asks, when I get some money, I'll contact you about these scummy contractors out there. Well, that's not really a question. Wilford, so employment lawyers generally can help with if you've been dismissed and you don't think and you may not have obtained the correct amount of severance. Employment lawyer can assist with obtaining you more money in that situation. If your grievance is outside of that, it may be that you need to go to a different type of lawyer, like a commercial litigation lawyer. So Beverly asks, if I accept a remote work position, can my employer change this to have me go in the office? Depends what your contract says. I bet you, if they're making you sign an employment contract, I bet you it says something to that effect. Employers are very alive to this right now because they had to deal with all of the problems that arose from taking 3/4 to 100% of their workforce during the pandemic, shifting them home, and then calling some of them back, and having a percentage of those people get very upset about being forced back into the workplace. And there were all kinds of questions of, if you have been a long-time employee prior to the pandemic and they just sent you home for the pandemic, did the employer have the right? And a lot of these people moved, like they lived in Vancouver and then they moved 2.5 hours out of Vancouver because it was more affordable from a housing perspective, and now they can't come back to work. The employer's forcing them to come back to work, and this happened across the country. And to what extent did the employer have the right to force these people back? And the answer was, if you predated the pandemic as an employee, the employer, of course, could make you go back to the office. That's what that, I can't remember which, I think it was was it CRA? It was some sort of, I think it was, some sort of Service Canada or Citizenship and Immigration they were fighting over that issue. And that was in a union context, but that was the issue they were fighting over, the ability to work from home. Um, and but the employer is going to want to retain the right to have you be able to come back to the office. Now, if you were hired in the pandemic directly to a home position, I think there's an argument that you could make that says, no, these were, especially if your contract was silent on it, because most workers people didn't contemplate this at the time. There's an argument to say no, that a central term of my condition was working from home. If you force me to the office, you've constructively terminated my employment, and then I have severance remedies at that point. But they wouldn't be very large because the pandemic just happened. That means you only have a few years of service, depending on, again, how much you make and then your position. But your remedy, first of all, just so you understand here, Beverly, if they can't force you back to work, back into the office, your only remedy at law is to claim you've been constructively dismissed, which means you're firing yourself and going after severance, right? And if you're just starting, that's probably going to be a small amount of severance and probably not the remedy that you want. So what is your contract? You're just signing a contract now. Do you have a contract? If the answer is no, I think that it's very arguable that they can't force you back to work. But if they say you come back to work and you say no, they'll fire you and or you can trigger your constructive dismissal and you get severance, which would be small because you just started. Okay, so what is the remedy in the situation? But if they've explicitly covered it in your employment contract, which I expect they have, then it's whatever the contract says that you're signing. Can they force you to come back to the office? I bet you they can based on what's in the contract, but maybe not. Maybe the company didn't contemplate it. Maybe it's a small company. I don't know. But that's sort of the general rundown on remote work. And if it's as important to you that you be able to just maintain working at home, if your contract is silent on it, you could just roll the dice. But you could also be specific about it. And this is probably what I would do. This is a you choice, but probably what I would do is I would just say, you know what? It's very important to me that I continue to be working from home. I want to maintain the ability to work from home. And so I want it clear in the contract this is a remote work position. But I will say if you do that, and they do want you to come back to the office because, management changes, whatever it is that they want, and that happens in every company from time to time, if you have a no trade clause, so to speak, like they can't force you back to the office, they might just get rid of you because you're not rowing in their direction, right? And it wouldn't cost them very much. So because you're a fairly new employee. So I lots of questions or lots of different permutations there, Bev. You can talk to an employment lawyer if you want. Again, you can reach us at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. But given that you're just starting and the remedies involved, most likely, yeah, if they want you to go back, you're probably going to have to go back. And as I say, a lot of times the solution there is probably amicable. They say we want you to come back. You say something like, "Oh, I can, but I prefer not to, and here's why." Or if you live 4 hours away from your employer, you want them to know that up front. So, okay, Sean asks, I'm on leave for stress. The workplace environment is too toxic. I can't return. Am I entitled to severance, or do I have to go back to back? And then, if the workplace is still a problem, seek severance. Oh, okay. So, in order to get severance, okay, you have to be terminated without cause, and then you got to determine what the value of that severance is. Pardon me. You got to determine what the value of that severance is. And the determination of that value is, what does your employment contract say? Okay. And does it allow you to get common law severance? If it allows you to get common law severance, then it's a function of your age, your length of service, and your position divided by your efforts to look for a new job and or whatever you earned at a new job being subtracted from your severance, and then out comes a number on the other side. Okay, so It's a gatekeeper function with your contract, and then a quantum analysis for the rest of it. What a constructive dismissal is the employee saying the employer, in this case, through its actions, has de facto fired me. Okay. So a constructive dismissal is you get your employer, sorry, you have to get a judge to say, yeah, the employer in effect fired Sean. And since it did that, then we look at the contract and then we look at the quantum analysis, right? To see how much money you'd be entitled to. So it's an extra step. If you lose on that first step, okay, you effectively quit and you get nothing. So if you say I've been constructively dismissed, court says no, you get zero. Okay. And so you want to be right about that first piece. And to get to that first piece, there are two ways. Okay. One is that the employer breaches a fundamental term of your contract that you don't agree with. Okay. So I'll give you a classic example. Your employer reduces your salary by 30%. That's constructive dismissal. But only if you trigger it. If you don't, and you wait 2 months working under the reduced wage, you're deemed to have accepted it, and now that's the new condition of your employment, 30% less. And 6 months later, you can't just go, I've been constructively dismissed 6 months ago. Well, no, you accepted it. Okay, so you got a finite window to pull the trigger on this. So breach of fundamental term, and the judge has to agree, yeah, that was a fundamental term, and therefore the relationship has been severed. Okay. The other way to get there is that the employer indicates that it is effectively repudiated its contract of employment with the employee. It basically, through its actions, shows that it doesn't want to be your employer anymore. So that's where a toxic workplace falls under. Okay, and many employees say, well, actually, let me say this a different way. That branch of the constructive dismissal test is very hard to make out, and it's harder depending on what jurisdiction you're in. It'd be harder in BC than Ontario, for example. You have to have a lot of evidence, and it has to pass a subjective objective test. And what I mean by that is just because you think it's toxic or bullying and harassment or whatever the terminology you're going to use is, it has to objectively appear that way to a judge, which means you need a lot of evidence, emails or witnesses who can testify on your behalf. If it's just, I don't like the way they treated me, that's very, very difficult. It's going to be very, very, very difficult for you to prevail. Okay. So your testimony is probably not enough, but it depends how severe it is. I've had clients who, managers screamed in my client's face every day for years, and there were lots of witnesses. So it just depends on what it is. But Sean, I would, if you're not going to go back, like, you need to talk to an employment lawyer and find out if you got something. And what the path that you're arguing for is the hardest one in terms of pulling the trigger on a constructive dismissal. Okay, so you need to talk to an employment lawyer before you do anything, and you can do so. You want to reach us, employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Okay, question from David. I was off for 2 months on disability. I was denied my yearly bonus and was told it was because of those 2 months off. Can you be penalized for taking the time off? It's an interesting question. So I don't know how the cake of your bonus is made, if it's entirely discretionary or not. Did they say in writing, it's because you were on leave for disability that we didn't give you this bonus? I think that if they said that, I think you have a human rights complaint because they discriminated against you on the basis of your disability. But I'll just use BC for an example. Number one, your remedy would be confined to the extent of the bonus. Now, if your bonus is 75% of your wages, you probably want to do that. But if it's like $2,000, you probably don't want to do that, because it'll sour the relationship with your employer, and the chances are you're not going to be working there for too much longer. Yeah, so the remedy would be confined to to whatever you get out of the Human Rights Tribunal. The second point I was going to make is that the Human Rights Tribunal, I don't know what it's like elsewhere. I know in Ontario you can sort of graft together human rights claims into civil actions. You can't do that in BC because they're separate jurisdictions. But the Human Rights Tribunal in BC is famously backlogged, for 4+ years to get a resolution from instantiation to end if it has to go to a hearing. So, I don't, not only would your job, if you went that route, probably be eventually in jeopardy, because it's just, you're bringing a legal action of some sort against, it's not quite a court action, but it's a legal action against your employer. You wouldn't get resolution potentially for years unless it's settled. So the answer is no, they can't do this, or they probably can't do it, but it depends again on what's in the phraseology for the bonus. If it's entirely discretionary, then maybe, but if you got it every year for 10 years and then you just didn't get it because you were on disability, I keep saying the same thing. I think your solution here is amicable. I think you should talk to your boss and say, like, come on, I was on medical leave. Here's my medical note. I think this is unfair. I'll just say that, or can you? I wouldn't even phrase it as unfair. My family was relying on this bonus. Can you help me out, et cetera, et cetera. The problem is, David, the longer an employee has been in a given location, the more that employee, and I'm not saying you've done this, I'm just saying generally I've observed this, both in my business history and also my history as a lawyer. Employees tend to feel that the employer owes them more, and they're more entitled, and they forget what the actual what a business is. And in a situation like this, look at the value. If it's not that much, and this is just a principle thing for you, be careful about being too squeaky a wheel, right? Because sometimes when you get too squeaky as a wheel, they just say, we've had enough of you. You're a health liability, and you're agitating for money and telling us we're wrong, and you're not rowing in our direction, so we're getting you out of here, right? And that might be a disaster for you, depending on what this job is, and if you need it, if it pays you way over market value, et cetera. I would caution everybody who I hear all the time, it's the principle. It's like, yeah, okay, it might be the principle, but principle isn't going to put food on your plate for your family or pay your mortgage, right? And so I would encourage everyone, when they make these decisions, to take a step back and look at this emotionlessly and from a 50-foot perspective and go, what is the best course of action for myself and my family over the short, medium, and long term? And then I would make your decision based on that. So in your case, David, yeah, you probably got something. Is there a point to it, though? Not if it's like $1,500. Most likely not. And if you are gonna try to get the company to redress this, there's a way to gripe, and I would gripe in a way that plays on their sympathies, is not accusatory, and is amicable, right, and friendly. Because I don't know your situation, what your employer is like, but if they did that to you, I imagine that this is not a situation where if you go barking at them, they might say you're not rowing in your direction, and just put your job in jeopardy. I don't know, but I've seen it over and over and over again, so I would just caution you with that. All right, we'll probably do this as the last one. We're out of time. I don't know who this is. Abby, I think. My counterpart was fired. I was asked to take over his work while HR is interviewing candidates. Is it legal to ask for a pay increase until they find a replacement? Well, it's never illegal to. Well, you can. This has nothing to do with the law. Okay. This has nothing to do with the law. This is entirely about your relationship with your employer. I had a colleague once who they asked him. This is when I was running call centers for major technology corporations, and one of our head offices was in an American city, and that American city lost a key manager, and they asked one of my employees, "Hey, would you go run that call center for us?" And he said, "Sure, but I want a 75% bonus," or something, like some outrageous amount. and he had them over a barrel, and they said yes. Okay, it was great negotiating. Um, in your case, it just depends. Like you're a single point of failure right now. It seems like, so you got a lot of leverage, but that leverage will evaporate when they bring more people on. So could you ask for a bonus for doing this? You could. Could you ask for a raise? Certainly, you could do that. Um, it's you've got a lot of leverage right now, but you need to understand what your value is to the company and how your company would react to it. Some companies you can demand a raise and it's fine. Other companies will just say you're not pulling in the right direction. We're getting you out of here. But this has nothing to do with the law. It has everything to do with what's your relationship with your employer, what's your employer like, and what's your leverage at this moment in time. So I urge you to, if you're going to make a decision in this direction, to think about what's your best strategy for this, what's your worst case outcome, what's your best case outcome, and then sort of find a path that makes sense for you between that and how you're going to want to negotiate. Because like I said, my former colleague in that same situation, he recognized he had all the leverage and he was prepared to walk, and he just said, "Nah, you're going to pay me a 70. I think it was a 75% raise or something, plus a massive signing bonus to do this, or I'm not doing it." And they folded, right? But it easily could have gone a different direction for him. But he had the cards, and he was prepared to risk whatever came out of that. So it just depends on your situation. If that's not you, maybe you want to go with a more sort of amicable approach to it. So anyway, that's it. That's all the time we have today. Great questions. As always, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. I am Dan Balkaran. I will see you again in 2 weeks at the same time to answer all your questions in employment law. Join us on August 8th with Madalena Vixney. She's going to get upset because I can never pronounce her name correctly, but I think it's Vixney. But join us then. Madalena will answer all of your questions, and have a great session with you next week. So please join us then. Other than that, have a wonderful, wonderful weekend. Thanks for your questions, and we'll see you again next week. Thank you.